Check. Hello, check. Check.
Yes, Mr. Chaudhary.
As per Honorable Court Order, I have submitted the next of kin certificate. Your
Mm.
Lordship. But they have not yet filed their affidavit in reply.
Yes, madam.
An instruction has been received from ADC, my lord,
Mm.
regarding their non-entitlement. So I would like to file the same on record, my.
Matter is of 2022.
Instruction received is 23.
That should not keep the court waiting. How much time would you need? Huh? 1 week. Okay, Miss M. Burman, appearing for the respondent authorities, have submitted that the instructions have been received and should like to place the same before this court in the form of an affidavit in opposition.
Please.
Mr. R.M. Chaudhary has submitted that the matter relates to the year 2022 and the respondents are yet to place on record their stand. Full stop. Considering the prayer of Ms. Burman, an opportunity of 10 days as a final opportunity is granted to the respondents to bring on record their stand in the matter. Full stop. You are appearing for?
Appearing for BTC law.
Mr. So-and-so appears for the BTC authorities. You are filing an affidavit? Would you file an affidavit, sir?
Also, I'll obtain instruction.
And he submits that he would also like to obtain instructions in the matter. Full stop. List this matter again after 2 weeks on a date to be fixed by the registry, by which time the respondent shall ensure that their stand is brought on record and the petitioner would be at liberty to file his response to the affidavit in opposition before the next date of listing. Yes.
Lord, matter relates to.
Yes, sir.
My lordship, my senior is on legs in court number 1. May the case be taken up to some time.
Have you filed your affidavit? The pleadings are complete. Pleadings are
It's a
complete.
question of law.
Okay.
The point involved in Miller, the act says
Hmm.
that BOT and all would function in accordance with the bylaw.
Hmm.
Bylaw says there has to be minimum of 15 members
Hmm.
who would be elected. Like in the instant case, Miller, the ARCS while approving the proceedings, approved only in respect of 11. In respect of 3, it was withheld.
Hmm.
Now we pray, since prescription in the bylaw is without 15, you cannot constitute the board of directors. Therefore, withhold the holding of election of chairman and vice president, chairman until the registrar takes a call on the remaining 3.
Okay.
Without that, they proceeded. Now the question is whether without first taking a call on the validity of the election of the 3 members,
Hmm.
the chairman and vice chairman can be elected.
Elected or not.
Having regard to the prescription that there has to be minimum 15. That is the point.
Can we have it after some time?
Yes.
Yes, we have to find out. However, but this court would not be sitting after 1 o'clock. So have it before that. Yes, madam.
Ma'am, please a lodge. In this matter, the respondent number 6 have filed an affidavit in opposition.
Respondent number 6.
Yes,
Who is respondent number 6? We don't have it on record. Huh?
I'm responding to that.
When did you file it?
24/9/25.
It has been submitted by Mr.
Yes, sir.
appearing for the respondent number 6 that an affidavit in opposition has been filed on 24/9/2025 with advance copies to the petitioner. You have a copy of it? Yes. Have you given the other respondents copies? Or, huh? Mr. Talukdar undertakes to serve copies on the remaining respondents. Full stop. The copy of the affidavit in opposition stated to be filed is not on record today. List this matter again after 3 weeks on a date to be fixed by the registry, by which time the petitioner may file their response to the affidavit in opposition if so advised. 3 weeks you file your affidavit in reply, we'll see.
Please kindly pass over the matter for detail.
You were required to file an additional affidavit. Have you filed it, madam?
Please, I don't have the information.
Whom are you appearing for? Whom are you appearing for? The petitioner. What do you want? Do you want a passover for the time being or do you want a passover for the day? Time being, a piece of material.
Petition.
A little later. Yes.
For the timing,
Huh?
pass over the matter for timing
Should the entire court sit after time, after some time?
after.
Should the court sit after some time?
For timing, can be.
I'm asking you, when everybody is taking a time being, should the court sit after 1 hour, allowing everybody to have some time beings? Huh?
6.
Yes?
Yeah, please, Lordship.
No.
Land acquisition.
Oh,
My land has been acquired in the year 2015. But formally acquired 11/5/22. But I have not-
22.
22.
Hmm.
11/5/22.
Huh.
Till today, I have not received the compensation amount. Action is still awaited.
Nearly a year, sir. Although notice in this case was issued on 28/2/2025.
We have received the letter from them, they are praying for some more time. 4 weeks
Ah.
time.
We'll keep that on. The respondents have not filed their affidavit in opposition to the writ petition. Full stop. You are Mr. G.C. Bora?
G.C.
Mr. G.C. Bora, learned counsel appearing for the petition has submitted that the matter relates to land acquisition and the petitioner is awaiting compensation.
Yes.
Full stop. Mr. A. Sharma, learned additional senior government advocate, has sought for 4 weeks' time to file
Lordship.
their response in the matter. Full stop. Let this matter be again listed on the first week of December on a date to be fixed by registry, by which date the respondents shall ensure that their stand is brought on record. Full stop. It is made clear that in the absence of the stand, the writ petition may be taken up on the materials available on record. Yes?
Well, matter pertains to the non-essential self-condition matter, NOC matter. Then, the similar matter has been already decided by this court.
Decided. Subsequent development relating to issuance of a notice on 9/9. That is the last order. In view of the subsequent development relating to the issuance of a notification.
That petition already issued, changed by them.
Okay.
And my application was submitted.
No, that could be so, but does it have any effect on your?
Not affected.
No. And what is a similar case you are saying? Should we?
Fine.
Can we dispose it upon that line?
Yes.
Have you seen?
They were supposed to file reply affidavit, Your Lordship.
If it is covered by some judgment, he's saying,
Already filed, Your Lordship.
could be done. If this judgment covers, if you agree that this judgment would cover, give her a copy. Unless she agrees, how can we say that both the councils have agreed that this is covered?
Take copy now.
Or it will be to your peril. We'll say that you have submitted that this judgment covers your case accordingly.
Similar issue has been, that's it.
Okay.
Similar circumstances, my lord.
Yes, Shri S. Hawk, learned counsel appearing for the petitioner submits that the grievance of the petitioner would be redressed if an order similar to the orders passed in WPC number 5020/2024 on 27/9/2024 is passed in the present case. Full stop. The learned counsel appearing for the respondents have submitted that in case the petitioner is satisfied with a similar order, they would have no objection. Full stop.
Well, that is also, my lord, inter-religion case, man.
Taking, just a minute, don't write, huh? Petitioner would not like to submit the instant proceedings. That is what you want to do.
My lord. I'm
The
not-
final order says, learned senior counsel appearing on behalf of the petitioner submits that the petitioners would not like to pursue the matter further.
Because, my lord, that NOC has already been issued.
In his case, NOC.
No, no, no.
Didn't get the
In
NOC.
this case, my lord,
In this case, the NOC has been issued.
issued, my lord.
In your
Last-
case,
last-
in your
before-
case, has the NOC been issued?
No.
The issue is whether you should be allowed to have an NOC or not.
No,
That is-
I did the NOC, my lord.
Huh? Yes, that is the issue. They are saying don't want to give an NOC. You are saying I need the NOC.
Yes.
You want a decision? Okay,
No,
yes.
Right now, my lord, I am up to your lordship, my lord, what your lordship.
Let us, okay.
My lord, what
You
I
want to
found-
file a reply?
My lord, in fact, my lord, DC had not filed any affidavit, my lord. The
Actually, the revenue department is silent.
the revenue department, my
Revenue
lord,
is
what
fine.
happened, my lord, the proceeding, my lord, is still pending before the DC, my lord. He has been.
Tell us your case. We will see whether the affidavit of the DC is required or not. If we find that the DC's stand is
Yes,
required,
Yeah,
apart
but
from the
can-
revenue department, we will take that into
Can-
consideration.
Can, yes, submit,
Perus
May I
order
submit, my lord?
25
One at a time,
my
madam.
lord, kindly submit the present status of the application, NOC, my lord. What they are doing, my lord.
Why
The
are they?
circle officer, my lord, has repeatedly forwarding the application to the DC, and DC has been repeatedly reverting back to the circle officer. Subsequently, my lord, the DC had forwarded to the department now, my lord. Kindly see the last order, see status, my lord.
Praying for grant of permission on self-permission bearing so-and-so applicant Sunil Deka.
So,
Then
all the
what
four
happened?
petition is suffering, my lord. So,
Additional affidavit in opposition. Where is your affidavit in opposition, madam?
So it was filed on 15/9/2025. 15/9.
Oh, it is quoted as an additional affidavit in opposition.
A typographical error.
Now, what is your stand? Why are you not giving it to him?
my lord, they are saying that it is up to the DC. If he needs some decision,
Yes,
that
your
it can be.
lordship, may kindly peruse page number 22, your lordship.
Yes.
Yes.
It says that the district commissioner exercises final statutory
Statutory discretion.
discretion. Now, his case is that the DC is neither rejecting it, neither he is allowing it. If it is rejected, he will have some avenue. If he does not, if he allows it, the case can be closed. Can we have some instruction from the DC as to why it is being reverted back again and again? When can you have the instruction? From the deputy commissioner? Yes, sir?
Chief, may I place one thing? Now,
Yes, yes.
going on, we have not filed any affidavit.
Yes, but
This is
otherwise,
an instruction we have received that revenue department has issued and not, has appointed a nodal officer to look into all these things. So how they can say that it's up to the DC? This is the letter, lordship. The nodal officer.
who has issued that notification?
That noted by the revenue department.
But that
Who is the
was
signatory?
9925, my lord.
Sir,
Sorry.
if I try to listen to both of them,
No, my lord. Okay.
okay, then we can we request the commissioner and secretary revenue and DM department and the deputy commissioner Nalbari to have a discussion in the court as to who is the authority who will either accept or reject the,
If that is the affidavit submitted by the revenue department by being the district commissioner, we are bound by that letter. Bound by that.
Actually, what has happened, your lordship?
Lordship may kindly peruse the page number 28, Your Lordship. So
It
the-
is an inter-religious sale permission.
For that reason, Your Lordship.
The nodal officer has to take the call. Yes.
Then he has to file an application before the nodal officer, he has to
No,
look
no, no,
into.
no.
Yeah.
Not send this particular case to the nodal officer yet. Maybe it's, it may be.
Okay, that's not.
That
Take down.
direction may
Heard-
be given, no?
Heard Mr. S. Hawk, learned counsel for the petitioner. It is the case of the petitioner that he had applied for permission permission for sale of a plot of land. On, when did you apply it?
Well, 5/7/2024, my lord.
5/7/2024.
Right.
Is it 5/7? 5/7/2024. And till date, the application filed by the petitioner has neither been accepted nor rejected
Yes.
by the concerned deputy commissioner. Full stop. Miss N. Bordelot, learned counsel appearing for the Department of Revenue, has referred to the affidavit in opposition to inform the court that as per the SOP, the district commissioner continues to be the statutory authority to grant or refuse NOC in land transfer cases, which is to be done within a period of 30 days from the date of the application, full stop. This affidavit was filed on 15/9/2025, full stop. Mr. H. Sharma, learned additional senior government advocate, has produced before this court an instruction dated 4/6/2025, whereby the Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management Department, you read, whereby the District Commissioner Nalbari has informed that pursuant to the order dated 26/5/2025, a joint secretary to the Government of Assam has been appointed as the state nodal officer for inter-religious land sale permission within bracket NOC matters. Full stop. The learned counsel for the respondents have jointly submitted that it may be a case where the deputy commissioner has not forwarded the case as of now to for consideration to the aforesaid state nodal officer. Full stop. That is what I said. Has perhaps not. I said the word perhaps. Have I not said? What did I say, Mr.? Both the councils have jointly submitted that. It may be, I said, it may be. I'm not saying it is. Full stop. List this matter again in the 3rd week of November, allowing Ms. Bordelot and Mr. H. Sharma, learned counsel appearing for the respondents to have appropriate instructions as to the reason why the application of the petitioner has not received consideration till date. At this stage, Mr. S. Hawk, learned counsel, has placed on record, has placed before this court a status report, which is a printout from the application tracking from the Seva Setu.
The last one, it was seen that well, it hasn't forwarded to the TM.
Where? To the?
And the disaster management has been already forwarded by the DC. Last one.
That the deputy district commissioner had forwarded the application to the department on 4/6/2025. Mr. Hawk has agreed to hand over a copy of the status printout to the learned counsel for the respondents to facilitate their obtaining of the instruction. Yes.
Page number 24.
Of? Yes.
9 of September 2025, that is the latest one.
Ah.
Inter-region sale transfer.
Ah.
It is, in page number 25, your lordship, point 2, 3, 4 is very clear. They are very clear, your lordship, what needs to be done. Probably it's somewhere stuck.
4.
Point number 3 and 4, your lord.
I think it is stuck between 3 and 4. Kindly have your,
That's why it's getting the.
so kindly have your instructions. It is a yes or a no.
Yes,
2024, he has taken some money from some person. He'll be in trouble otherwise.
Lordship, if it is not sent yet, Lordship, then may I suggest them to send it to the.
You do whatever has to be done. I just want the updated
Lordship,
instructions on the 3rd week of November.
Problem should be solved, my Lordship.
Yes or no, he will have his avenues. I said 3rd week of November.
Lordship, may I
On a date to be fixed by the registry will लिख दीजिए. Huh? Yes.
Lordship, may I get back the instructions?
Oh yes. लिखने लगे date. You give him a copy of the track status report so that he can have a.
I can hand over, but right now it would not be clear.
Give him a photocopy whenever you can. Throughout the day, I said you have agreed to do it.
Fine.
Yes. Yes. Yeah, পিছতে সেই চৌধুৰী ছাৰটো মাতি দিব.
It will file it during the course of the day, not just post it after the affidavit.
You will file it during the course of the day.
I think within an hour it will file.
By the last order dated 17/10/2025, a last opportunity was afforded to the respondents to file their affidavit in opposition. Full stop. Today, Mr. S. Bora, Learned Standing Council GMC, has submitted that the affidavit is in the course of filing, and the filing will be completed today. Full stop. Advance copies you have given, or you are yet to give? Okay. On receipt of advance copies of the affidavit in opposition, the petitioner shall be at liberty to file their reply, if any, to the affidavit in opposition within a period of 2 weeks hence. 1 week hence, full stop. List this matter again after 2 weeks on a date to be fixed by the registry, along with the affidavit in opposition and the reply filed by the petitioner, if any. It will come up in the 2nd week of November.
Item 2, pending letter.
Still not there.
Next Friday.
Heard Mr. K. N. Chaudhary, Learned Senior Counsel, appearing for the petition. Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Egan, appearing for the petitioner. Yes, madam. So and so appears for respondent number so and so. On the first call, a prayer was made for a passover for the time being. Full stop. On second call, none appears for the respondent number. Who was that?
The official respondent.
For the none appears for the official respondents. Full stop. List this matter again on the 7th of November 2025 for further consideration.
Item 4.
Yes.
Here I have filed for compensation for land acquisition. What happened, my lord?
Have you filed the additional affidavit in the matter?
I have
When
filed.
did you file it?
My lord, on 20. No, no.
On 24/9, you prayed that you should be given some time to file an additional.
File, my lord, that's
Huh.
nice.
You do not have the filing date.
My lord.
You have the date? No. It has been submitted by the Learned Counsel appearing for the petitioner that the additional affidavit
My lord.
has been filed by the petitioner pursuant to the liberty granted on 24/9/2025. Full stop. The said affidavit is, however, not on record. Full stop. Registry to list this matter again in the 3rd week of November, along with the additional affidavit filed by the petitioner. Full stop.
Fine.
Item 5.
Yes.
The son of the petitioner died, my lord, due to electrocution. And my lord, the investigation was sent to electric sub-inspector, my lord, expert inquiry was done. Then, my lord, petitioner made a claim before the authorities for granting compensation due to death. uh, due to electrocution, death by electrocution, but the respondent authorities my lord have not paid the compensation, and ultimately the petition is before lordship. Here it is clear, my lord.
There is some kind of a report that is called for from the chief electrical inspector or something.
If I'm appearing on behalf of Mr. S. Banik,
Yes.
Council, APDCL,
Hmm?
is on Lex court number 1.
Hmm.
Please kindly pass over the matter.
He is appearing for the APDCL
Appearing
on his behalf for the APDCL. Yes, now the APDCL has not filed an affidavit in opposition from the year 2024.
is on Lex court number 1.
Very well. Once he is on legs before this court, we would ask him the same question. Are you filing an affidavit in opposition in the matter? Would you like to or would you not like to? Kindly have the instructions and come back. We'll take it up after some time. Wait for 5 minutes.
I'm sorry, madam. I.
Oh, but we have already said none appears today for the respondents on second call.
I was on legs in court.
Okay, Mr. Chaudhary. He has now come, but we have already fixed it for the 7th.
Yeah.
Will with that item number 12. Where did sorry, item number 2. You said on the second call, the court was informed on the second call. Niche likhe. Later, Mr. S.K. Talukdar appeared for the respondents. Later, Mr. S.K. Talukdar appeared for the respondents and submitted that he was on his legs and therefore he could not come before this court. Full stop. However, on the consent of the councils, let the matter again be listed on the 7th as directed herein before.
Yes. I'm sorry, madam.
It's all right. I've just recorded
My
that.
junior colleague joined last week, my lord,
I know.
that she could not
I
appear.
know.
Well,
She must have gone outside because you were not there. Yes.
Supplementary list for admission, I think 9. Which is it?
Yes. Who appeared?
Regarding the on point of position, who is specific present there.
Hmm.
That was filed on 29. I'm sorry, my lord, I could not check whether it is on record or not. Last
It is
week.
there. It is there. But none appears for the petitioner. What to do? What do you say in your affidavit?
It is in, respondent number 4. You has filed affidavit and was asked to clarify that. Last order, my lord.
Ms. M. Borman, Learned Counsel, appearing for the respondents, has submitted that the affidavit on behalf of the respondent number 2 has been filed on 29/10/2025. You are appearing for whom, sir?
I'm for the private responsibility.
Mr. So-and-so appears for respondent number so-and-so. Full stop. None appears for the petitioner on call. List the matter again after 3 weeks on a date to be fixed by the registry, by which time the petitioner may file response to the affidavit in oppositions filed by the affidavits in opposition filed by the respondents. Full stop.
Petition in this matter, Your Lordship.
You have filed,
Yes, Your Lordship.
but it is not on record. It has not come today.
It is.
Oh, it has
filed
come. Yes.
prior.
This is for what?
Oh, Your Lordship. In the conduct of the.
What is the prayer in the IA?
So my prayer is, because this repetition is pending in this, Your Lordship, I am not being allowed to, Your Lordship, refurnish my house, not to paint my house, Your Lordship. There is no interim order, Your Lordship.
Diwali is gone. Right now, there is no urgency to repaint the house. We'll have it on the 3rd week of November. Read petition goes this way and that way. Either you paint your house or you don't paint your house.
So, they did me.
3rd week of November. We are not fixing any dates now. We are just giving a week.
Of like,
Item number 20, no? Sir, Mr. Bhia.
That matter, my lord, regarding that administrative approval was not given, and in the affidavit, my lord, they have said that it will be done in a phase manner, my lord. So, my lord, if they are doing it in a phase manner, basing on the stand taken, if my lordship is pleased, my lord, that can be disposed of, my lord.
Is that so, Mr. Sharma? Can we dispose it of on that way?
No, that's because you have categorically stated paragraph 4 of
Just
the
a minute, I'll have to go through the prayer once.
Well,
If it suffices, we will dispose it of.
Page 41. Yeah.
Forfeit accord administrative approval schemes already placed before him. Yes, take down. You're standing the affidavit, which page?
affidavit lordship at page 257. Paragraph 4.
Paragraph 4.
My lord.
Yes, take down. Heard Mr. A.R. Bhuya, learned counsel, appearing for the petitioners. Petitioners, full stop. The grievance raised in this writ petition was that the respondent authorities were not granting the administrative approval for the MGNREGA schemes under their respective Gaon Panchayats. Full stop. It was the case of the petitioners that all the necessary procedures, including approval by the respective Gram Sabhas, non-duplicacy, feasibility clearance were obtained, and technical sanction had also been accorded. Full stop. However, the respondents, for no apparent reasons, were not granting or rejecting the administrative approval for these schemes. Full stop. Mr. H. Sharma, learned counsel, appearing for the respondents, has referred to the affidavit in opposition filed on behalf of the respondent number 4, namely the Assistant Commissioner, Hailakandi, Assam, and referred to paragraph 4 of the affidavit to submit that the process for according administrative approval is underway and the approvals are being granted as per the norms and guidelines of the MGNREGA. Full stop. It is being done in a phase-wise manner, and the schemes in issue in this writ petition would also receive adequate attention as and when their terms come up. Full stop. In view of the submissions made in view of the assertions made in the affidavit in opposition, Mr. A.R. Bhuya, learned counsel, appearing for the petitioner, has submitted that this writ petition may be closed on the assurance of the respondents that the steps are being taken. Full stop. He may, however, be given the liberty. The petitioners may, however, be given the liberty to approach this court again in case there is inappropriate delay in the consideration of these schemes in issue. Full stop. In view of the submissions made by Mr. A.R. Bhuya and the affidavit in opposition filed by the respondent number 4, this writ petition is closed at this stage on the basis of the assurance given by the state respondents that the schemes in issue would receive their due consideration in as short time as the procedure allows. Full stop. The petitioners shall be at liberty to approach this court in case approach this court again in case the assurances are not adhered to.
Instead of close, Milord, can it be?
Sorry?
Instead of word close, Milord, can it be disposed of?
Is disposed of.
One. Well,
9 years.
In this matter, my lord, the response of the state are required, not yet final.
For the respondent number 6,
It was already filed.
I filed the affidavit.
Button up your coat. Go out.
Your lordship, the button just torn up while coming from the.
Okay. So you have filed your affidavit?
Yes, sir.
Okay. Then take a seat. We should not see the unbuttoned coat. When? Okay, 112. 6 has filed it on 892025. Who else remains?
State respondent, the revenue and the deputy commissioner.
A writ petition, Mr. Bhattacharya, a writ petition is basically against an action of the state, asking directions to the state. Everybody else is trying to support you except the state itself. Why is the affidavit not coming on? It's a matter of 2022. On the next date, either the affidavit or the person with the instructions. Any instructions available with you? So either he come to answer it. Heard Ms. So-and-so counsel appearing for the petitioner. The affidavit in opposition on behalf of the respondent number 2 and the respondent number 6 have been filed on 1/12/2022 and 8/9/2025 respectively. There is no response to the writ petition from the government authorities, full stop. Mr. A. Bhattacharya has submitted that they are yet to receive the instructions. Yes, we are, I think you were appearing for 3. 3. So what we will do is, that is what we just told him, either the response by the next date of listing or the deputy commissioner comes and explains us the instructions. It is 2022 matter. So yes, Mr. D. Nath appearing for the respondent number, Mr. D. Nath, learned senior government advocate, appearing for the respondent number 4 and 5 have sought for some time to file the response, full stop, keeping in view the fact that the writ petition had been initiated in the year 2022, this court reluctantly grants 4 weeks time to the respondent authorities to file their affidavit in opposition in the matter, full stop. It is made clear that on the next day, if the affidavit in opposition is not on record, the incumbent holding the post of respondent number 4 as on that day shall remain present in the court to explain the circumstances in which the delay in responding to the affidavit to the writ petition has been caused, full stop. List this matter again in the 2nd week of December, by which time, if any affidavit in opposition is filed by the respondent number 3 and 4 by the state respondents, the petitioner would be at liberty to file their response to the same along with their response to the other affidavits filed by the other respondents, full stop. Yes, would do.
Okay. Item 5 for timing.
Mr. Banik,
Eight pieces of-
your response would be necessary.
Yes, necessary, but there would be another thing, if my lord would have the electricity at for a moment, although someone.
If we go through all that,
No,
then
no,
we'll
no,
take
no.
it up for disposal
There has to be essentially a report
by the
by the
chief electrical inspector. Who brings it up?
That's the appropriate government.
Who is the appropriate government?
The state government would tell it because the.
Who is the
inspector
state
report
government?
Necessary for fixing.
But then you would have some stand on it
What I'm saying is that.
unless they come up with it.
Otherwise also there will be some amount of compensation, but the report would give a proper picture as to what it would be. I'm not against it. For a moment.
What this court wants to know is, as of now, are you planning to file an affidavit
We
in
would.
opposition?
Certainly would, but in the fitness of things, he needs to complete the inspector, even in other cases also. It's a
In
government-
most of the
lordship,
cases,
something
that is the
for-
first question I asked, the report from the chief electrical inspector.
But here the APDCL is the party.
Could be. The chief electrical inspector is a separate entity from the APDCL.
Absolutely.
Here my APDCL is the party, deputy general manager and the.
You do not want the chief electrical inspector to be a party, or would you like him to be a party because without his report, this court or even the law that you are depending upon does not allow consideration of a compensation. The report of the chief electrical inspector is going to say to what extent the APDCL was responsible and if you were responsible to some extent. That is all.
I'll make party.
It has been pointed out by Mr. S. Banik, Standing Council, APDCL, that the report of the Chief Electrical Inspector would be necessary for a proper adjudication of the matter. Being informed thus, the Learned Counsel for the petitioner has sought for some time to move an appropriate application to impede the necessary party. Full stop. Mr. Banik has also submitted that they would like to file an affidavit in opposition in the matter. Full stop. List the matter again after 2 weeks, allowing the petitioner to file an appropriate application for impediment. What is this?
Here it is a case.
Okay.
Madam,
You are allowed to impede someone else. Have you filed the
I am.
no? Have you filed the amended cost title?
I'll.
When will you file? If he is not a party in the memo of parties, we cannot pass any orders. We cannot issue him notice.
Yes, no, I'll make this city electrical.
No. This Mr. Kamaikha Singh.
County Singh is a party man.
How?
Amended procedure already has been filed, madam.
Amended application has been filed. Have you filed the amended cost title is what I'm asking you.
Yes.
Oh, yes, it has been filed. Okay, list this matter again after Kumangolo. 2 weeks, allowing the petitioner to file an application for impediment of necessary parties. Full stop. The APDCL in the meantime may also file their response if so advised.
May I brief, subject to correction below? Let the inspector's report come, thereafter we find. It would bring a proper stand on the relief as well.
Whatever you want to say, you say. You wait for him, then you will draft an affidavit in his lines. Something we do not think we should allow.
Okay, please.
Yes.
All right.
Contempt. Okay. Order dated.
There are two directions, one to hand over the land and other to assess the acquisition compensation, the requisition compensation. Land has been handed over, the requisition compensation has been assessed, that has been challenged in the writ petition, that has been already disposed of as the direction is given to reassess the again.
Two.
Yes. Reassess the value again.
So what happens to this contempt?
That's not goes.
In the view of
This, no, this will go.
This is.
It will go.
paragraph 26.
Had Mr. So-and-so, Learned Counsel appearing for the petitioner. Also heard Mr. D. Nath, Learned Senior Government Advocate, appear.
It's a contempt.
Okay, heard Mr. D. Nath appearing for the respondents. Full stop. It has been submitted by both the parties in tandem that the directions issued by the order dated 25/7/2022 in WPC number 1127 of 2022, comma, non-compliance of which had been alleged in the contempt petition has undergone further litigation. Full stop. By the order dated 882025 passed in WPC 1436 of 2024, comma, this court has directed the collector to decide the requisition compensation afresh in view of the determination made in the writ petition and to pay the compensation with applicable interest, if any. Full stop. The Learned Counsel for the parties submit that nothing survives for adjudication in this present contempt petition and it may be closed. Full stop. In view of the submissions made by the Learned Counsel for the parties, this contempt petition is closed. A copy of the order dated 882025 passed in WPC 1436 of 2024 is kept on record of this case, marked as X. Yes.
There are two cases, madam. Both.
Both seems. Item number
10 and 11.
10 and 11, দুইটা disposed of.
Hello.
Separate order. Separate orders will come, although the subject matter is the same. Okay, separate. Yes, 12. Yes.
Lausiman note 28, October 25 Milot. When is the final justice? In this case, in fact, madam, we have formality, we have made party to the respondent, Milot. In fact, they are not necessary in this. We have events against the state authority, Milot.
This being a formal forum, let us not be informal. If there is a formality, let us complete it.
Yes, Milot.
So what now to
That's
unsub
the-
notice? Huh?
My lord,
Completed.
My lord, no. Milot, respondent number 4.2, Milot, same residence, Milot, he only filed, appeared before this court. So far as regarding 4.12, there's, Milot, there are no response.
Who appears for 4.2?
Who am appearing, Milot? The same, Milot, same.
And the
residence.
same residence,
Yes,
why
madam,
the
he-
others are?
They are not residing in the same. 4.
Otherwise, the
Or
address is the
instructed.
same. Otherwise, the address is the same. Otherwise, the address is the same for all.
But the petitioner is same, but the
Address
they
same.
resides in a different, Milot. This is.
delaying
house
this
belongs to
process,
the
Milot.
father.
Huh?
This house belongs to the father.
Ah.
The other siblings, they are not residing there.
So it belongs
I
to,
am a substituted legal heir of the respondent number
it belongs to the, you are appearing for the respondent number 2
2, only 4D.
and 1.
4.1,
4.3,
and
4.4 and 5.
Where do I find
4.3 and 4 are the daughters, my lord.
Just a minute, where do I find that point? Not being able to find out.
Amended cost title, my lord.
Huh? That is what I'm
Amended cost title,
trying.
amended cost.
Is that amended cost title? Amended cost title?
Okay. 4.3.
Then we have, just a minute.
4A, 4B.
A, B, C, and D.
Yes.
C and D are the daughters, my lord, who are married, my lord.
Huh.
Even the other brother, 4A also doesn't.
And have you filed your affidavit?
Then, my lord,
What to do about the steps on them?
Yes.
What to do?
Then he's the only person to give us a correct address so that we could file a justice service.
Oh, he is not,
Since, they are-
he
they are
is
his-
not so big-hearted.
No, they are his sisters, Milords. Their sister
He
residence.
is not so big-hearted professionally. Otherwise, he is. We have to say he is the
This
best person you
is
can meet in
Milord
life.
is pending, Milord, now.
Hmm?
He's the only person to help us, Milord, to give proper address, Milord.
I'll try to collect, my lord.
So that we could file the. Then we could file the justice service. Milord.
Mr. P.K. Dekar, Learned Counsel, appearing for the petitioner, has prayed that he may be allowed to take dusty steps on the respondent number, respondents arrayed as respondent number 4A, 4C, and 4D,
And 5, Milord.
and 5.
5, dear uncle.
And 5, full stop, since repeated attempts to have notices served upon them by way of by way of postal delivery
Yes.
has failed, full stop. Mr. B. Kaushik, Learned Counsel, appearing for the respondent number 4B, has submitted that he would require some time to file his affidavit in opposition to the writ petition, full stop. Prayers made by both the counsels are allowed. The petitioner may take dusty steps on the respondents number 4A, C, and D,
And 5.
and 5, which notices would be routed through the registry of this court within a period of 7 days, full stop. Mr. B. Kaushik may file the affidavit in opposition on behalf of respondent number 4B within a period of 4 weeks from today, full stop. Mr. P.K. Dekar Learned Counsel has requested Mr. B. Kaushik to furnish the addresses of to furnish updated addresses of the respondents arrays 4A, 4C, 4D, and 5. And Mr. Kaushik has assured that if the same are available, he would cooperate. Full stop. for appropriate adjudication of, full stop now, for appropriate adjudication of the matter, full stop. In view of the above, place this matter again in the second week of December, along with the affidavit to be filed by the petitioner with regard to the service with regard to the dusty service of notices.
The record of the government is also necessary.
Let your, let the notices be complete. Let your response be on record. Government record will come on the next day. Yes.
I received instruction from the petitioner, my lord.
Not to press.
Complied with my, like to press this.
Yes. Mr. So-and-so, learned counsel, appearing for the petitioner has submitted that he has instructions that the orders of which violation had been complained of has been complied by the respondents. Full stop. Ms. Borua appearing for the respondents. For the sole respondent has also made a similar submission regarding compliance of the orders. Full stop. This contempt petition is therefore closed on compliance. Very nice. Yes, madam.
789, today I have filed affidavit in opposition, madam.
I have to file reply.
And for 10, we have already filed, okay?
Lordship, and for 2, 3, 4, 5, and 6. We have already filed our affidavit.
And in that also, madam, I have to reply.
You have to file your reply. It has been submitted by Ms. A. Gayan, learned counsel, appearing for the respondent number
1789.
1789, that an affidavit in opposition has been filed today morning. Full stop. Learned counsel for the petitioner acknowledges receipt of a copy of the said opposition and prays for an opportunity to file the affidavit in reply to the same. Full stop. Place this matter again after 4 weeks, allowing the petitioner to file his.
Matter is relating to election of the labor association in ONGC. Since January 2025, the election is under all rules. So there is an urgency and their prayer is not.
If the affidavit has been filed today in opposition,
So we have already filed the.
you have. If her affidavit was not necessary, she would not have filed it.
No, okay.
If there is an affidavit in opposition, can we deny him an opportunity?
Give it to
You are appearing for respondent number?
10.
Huh?
Other association.
Respondent number 10. Now the election of January, you filed an affidavit in May.
Okay.
4 months. Let us give him 4 weeks.
Because what's the urgency of the matter? Not to 2 weeks or 3 weeks, maybe probably in my opinion sufficient. Because not for what more.
You can do it in 3 weeks. List the matter after 3 weeks on a date to be fixed by the registry, allowing the petitioner to file his affidavit when responsive.
Starting order time.
What is the interim order? Staying the whole, huh?
Up to whole election.
So the earlier body is continuing for the last 1 year. Oh, I should have put moving. These are constitutional processes, election. Why should the High Court be brought in? Yes.
Regarding item number 16, we have complied with the order here.
Item number
16.
16.
Item 15 LC, I have taken steps and
No,
item 15.
no, she was submitting on item 16.
Yes.
Are you appearing, sir?
Yes, so my lord, item number 16, my lord. But how much is the order of especially for this election?
He says that it has already been complied with.
In page number 31 of my affidavit. Your Lord.
Contempt 634.
Yes.
Your affidavit in opposition. What did you say there?
Yes.
What was the?
First on speaking order. Your Lord.
Where is the speaking order?
Page number 31. It was passed on 10/12/2024.
And just a minute, just tell us. Okay. Yes. Pursuant to the order dated 22/5/2024 passed by this court in WPC number 1884 of 2024, non-compliance of which had been alleged in this contempt petition, an order dated 10/12/2024 has been placed on record by the respondents asserting that the orders passed by this court has been complied with. Full stop. Ms. N. Fukon, Ms. K. Fukon, N. Fukon is secondary. Ms. K. Fukon, Learned Counsel has submitted that the order dated 10/12/2024 suffices the requirements of the orders passed in the writ petition by this court. Full stop. We have gone through the order. Full stop. There appears to be substantial compliance of the orders passed in the writ petition. Full stop. In that view of the matter, this contempt case is closed. However, the petitioner would be at liberty to assail the order dated 10/12/2024 if so advised. You have the liberty. And 15?
In Lordship, my friend can appear Lordship in my case, Lordship, I take mistake.
What was the order in your case?
Similar.
Same. So that have you seen that order? 10/12/2024. What was your writ petition number? Same writ petition number.
Not same list, but still
The same order.
There that chief executive officer, he is no longer in that post.
No, we are not on that, Ms. Fukon. Help us by finding out whether the order passed, whether order which he is complaining non-compliance of. If your disorder suffices that, then we say that yes, it has been done. Why should we go for lengthy process? Kindly show her the or give her a copy of the contempt petition.
And my friend's name may kindly be shown on the court district.
If you show it today, we can finish it today.
She'll give her.
Okay. The Learned Counsel for the petitioner has submitted that the order of which violation has been complained of in this contempt petition is the same order which was in issue in contempt case number 634 of 2024. Full stop. This court has requested Ms. K. Fukon. You are government advocate?
This is a contempt matter.
Has requested Ms. K. Fukon to go through the contents of the contempt case number 436 of 2025 also to verify and assist this court to find out if the same order, if the order dated 10/12/2024, which was one of the reasons for closing contempt case number 634 of 2024, would suffice the compliance in this contempt petition also. Full stop. Please the matter again after a week.
Please date may kindly given a receipt in November 13 or 14.
13 or 14, it will not be possible. You'll have to go a little beyond. On 20th of November 2025, allowing Ms. K. Fukon to assist this court.
Extra copy.
An extra copy of the contempt petition will be supplied by the counsel for the petitioner on Ms. K. Fukon. Yes. This is for substitution. Yes, sir.
I mean that first title directs the to submit. We have given it because
There is an IA on the top of the list by Mr. Roy Chaudhary.
3308, but I was not praised because he was not filing. I was appealing for the respondent number 7.
Okay.
He was not filing for the substitution of the Fukon. Then I filed an application, but he was for inadvertent reason was not listed. His application came for substitution.
Yes.
That was allowed. So 3308.
Then his application is the number
3308. 330.
No, your 3308 is your application. Which application was allowed, sir?
Last omission.
Substitution, because four.
That substitution IA number do you have, sir? It has been disposed of, your application?
My IS.
Your application খন দিয়ক। That is what we are saying. গোটেইখন IA দিয়ক, মই বিচাৰিব লাগিব। Okay.
Same, there are two IS file, one is by.
No, this is not. Next, আৰু এখন disposed of খন চাওক। Is it disposed of? Huh?
2152.
Substitute the name of respondent number 7 by his legal heir.
3152.
31? আৰু এখন আছে নেকি, sir? You have two application, two IAs.
IA, one is 3308.
Huh?
and
One
the
is 3309.
3309. 3309, Bala, after the father expired, the son, who is the present respondent number 7,
It is for the respondent.
respondent. I am for the respondent.
Huh?
Bala, I applied for mutation because the.
No, it is not on the subject matter of a substitution, is it not?
No,
It is, okay.
330 is for substitution.
Just a minute then. In view of the orders passed in IA civil number 3152 of 2025 on 13/10/2025, comma, Mr. P.K. Roy Chaudhary submits that the IA 3308 of 2025 would not require any further adjudication and may be closed. The submission made is not objected to by the learned counsel appearing for the writ petitioner. Full stop. In view of the above, IA 3308 of 2025 is disposed of as not pressed. So we close that first.
And on 3309, Bala,
Just
I paid
yes,
for the
so-
mutation of my name in place of my father, which
But-
they verbally say because of the pendency of the repetition, they will not. They are keeping it.
Is there an is there
I
any-
have placed the track.
is there any stay order by this court not to allow the mutation? Do you have any objection to this?
Yes, my lord.
Have you filed your affidavit?
Yes, within 1 week, I will.
The lordship will just take into consideration. My lord, there was a read court's direction for demarcation by the circle officer. There was an order from the circle officer. Circle officer placed that he doesn't have a position. I am in position. Actual, everything was clear. He came before this high court, my lord, on where the repetition is not maintainable. 147 appeal lies. And my lord, is a disputed question of fact. Then, my lord, only on this plea, notice was issued. Now, my lord, only taking the consideration that I don't get the mutation and I cannot construct my building, my lord, he is keeping it pending, my lord. He cannot object to this, my lord. His repetition is not maintainable. And I have annexed the circle. Please, let me finish. Well, and the circle officer report is there. Your lordship will find it's clear that he doesn't have position. I am in position. I have been the settlement. I am the patta holder. And he is the power of attorney holder. How he comes from behalf of somebody and comes and says, well, this is, and now again, this power of attorney holder files a civil suit in the writ court, in the civil court. And they, because if there is a suit pending over there, my lord, the form 50, I cannot get it. And now he files a writ petition so that I cannot get a mutation order. These are all things going on, my lord. There is no injunction in the civil court. There is no stay order in the writ petition.
My lord, one thing, my lord, with all respect to seniors, my lord, that civil case is filed. I have no knowledge, my lord. I don't know what is a civil number. Secondly, my lord, last 1.5 years, this repetition pending, he has not come forward to file any preliminary objection or affidavit in opposition. Now only he has raised this objection.
On the very
So
first day, I
I-
was on a
I
caveat. I
should
have
have given some-
objected. On caveat, I have objected. There was no stay order.
My lord, one thing, my lord, his land in Pata, 1400, land is 1 bigha, 4 kata 7 lasa. But when remarks column, it becomes 4 bighas, my lord. And this honorable court in earlier repetition directed that you demarcate my land 205. What circle officer has done, he has not demarcated my land. He demarcated some land and with the observation that where their construction is started, this is all right, they are in possession. But the direction of this honorable high court was flouted. We have filed in contempt. Then with the same time, we have filed 2 writ petition. Then the contempt court says that since writ petition going on, your address will be, your revenge will be addressed by this writ court. But no affidavit is filed today, and respondent number died, for 7 died. That is why case is pending. Now it is regular. So it may be heard in a petition hearing. Until then, opportunity may be given to file the objection of his
if
This is my humble
petition is
prayer.
given in my name,
On merit, if
I am
it
the
goes,
party in the proceeding, what will happen?
it is also our prayer in interim prayer that let the construction be stayed. They have not come forward.
Who deals with the mutation part?
Circle officer, the revenue authorities.
My lord,
He has made an application.
I am made it.
Yes, Mr. Chaudhary's client has made a application. Where is that? Is it there in on record?
Track record, but I have given the.
Where is it?
But they do at page 39 and 40, under process.
Pendency of a litigation
No.
of a writ petition.
Not reflected, but they.
No, I'm just asking if there's a writ petition pending by naming some plot of land where no orders have been passed for stay, yet the deputy commissioner can. So they will, so on presumption of our knowledge, they will keep everything
my lord,
hanging.
why they cannot do?
Same thing in the.
Yes.
What is civil case, my kindly, my lord, that things are.
Kindly tell us a convenient date.
My lord, after 1 week, my lord, any convenient that it should be heard completely. Till then, admission hearing.
But till then, no mutation, that you what you have to say.
No, we will not say whether mutation or not mutation.
Yes.
We'll say we'll take up the matter.
And
Let it be to your convenience. He cannot do it on the next week. When can you do it?
But I can do it today itself. If he is ready, I will do it today.
no, I have to file objection to this.
Not necessary. You are asking us to dispose of the writ petition. Why should we wait for an
Yes.
objection in the IA? We dispose of the writ petition matter ends. INOI.
Then, my lord,
Tuesday, Tuesday,
that may be given.
Tuesday, madam.
Admission hearing.
6th is a heavy board. 6th may not be
Eight.
possible.
8.
8th, sir, we shall have to meet you elsewhere.
Sorry.
The Saturday we'll meet somewhere else for.
The holiday.
Ah,
A holiday, my lord.
so therefore I said we could meet somewhere else. Yes. 7th. 7th,
Well, what I agree.
we'll take it up for disposal.
My lord, then my lord, I don't have an affidavit to file because I will verbally say only on the law points.
The absence of an affidavit is to your peril,
Well,
not to his.
I will file, my lord.
At the consent of the learned counsel for the parties, who have submitted after some hearing, after some arguments, that the matter may be taken up for final disposal, list this matter again on the 7th of November 2025, when an attempt shall be made to dispose of the writ petition.
If so, desires, then affidavit I mean.
We have not stopped you. We do not stop anybody.
Yes. Oblige.
Wait, Vidala.
Yes, sir.
We have filed this IA because there are certain intervening developments. First, just to give a glimpse of the case, if a lordship should kindly take the writ petition, my lord,
Read petition, yes, by the read petition from the
with
beginning.
an idea of what is the point involved. Please come to page 99, my lord. My lord, this is the tender for construction of second rail cum road bridge over Brahmaputra River. This, and the RFP has been issued by the NF Railway. Please come to page 99, my lord.
Yes.
Now, please come to 2 towards the bottom of the page.
Yes.
There should not be history of collapse of superstructure, substructure of any span of a bridge, flyover, viaduct, metro link, work during construction service in the last 3 years, ending last day of the month previous to one in which the tender is invited. Undertaking in this regard shall be submitted along with the pay. Now, my lord, the petitioner is a party, has got wide experience in construction, my lord. In fact, the second bridge over Brahmaputra at Kolia Bhamura has been constructed by the petitioner. Then, my lord, bridge connecting Matskwa with North Guwahati is also being constructed by this party.
Okay.
Then, my lord, Jogi Gopa, there is a second bridge in Jogi Gopa
that bridge is also being constructed by the petitioner.
Okay.
60% of the work is completed. And recently, my lord, they have also got a contract worth 1,249 crore from the NF Railway for construction of, my lord, viaduct, embankment, etc. in this Deepor Bill area. So this is the, my lord, standing of the petitioner. Now, what had happened in Patna over river Ganges, my lord, a particular bridge was being constructed. There, my lord, there was some, mishap took place, as a result of which a PIL came to be filed by the Patna High Court. Now, if I may permit, if Lordship permits me, I would like to place the order of the Patna High Court at page 200. Just to give a background of the case, you know. Please come to page 201. It's part of the Patna High Court order. In fact, my lord, an US consultant made the design.
Page, I'm sorry.
Page number 201.
20. Yes, sir,
The
201.
design of the bridge of the over river Ganges, my lord, it was made by an US based firm and it was rated by IIT Delhi. Now, para 3, learned Advocate General also informs us that agency appointed was to have design prepared through a consultant. The consultant was appointed by the agency and design was also sent for approval to an expert who was chosen by the state from a panel of 3 submitted by the agency. Only one expert affirmation construction was commenced, which has been stalled due to collapsing of certain spans, which had been collapsed only on account of they being extra dose, as is the prima facie assumption as of now. Design would now be redone and remodeled with the modified technology, and in any event, since the agency has taken upon itself the liability in support of building the collapse span with no extra cost to the government, we are of the opinion that public interest litigation can be pushed. My lord, this is the situation regarding the collapse which took place, because apparently there seems to be some design fault there. Now, look, this particular clause which I have read at page 99, it does not contain the circumstances when a collapse should be attributed to the petitioner. If it is on account of force majeure, if it is on account of reasons which is beyond the control of the particular bidder or the contractor, then what happens? Be that as it may, my lord, when we move this, then our prayer in the petition was that this clause should not be insisted upon while determining the tender. Now, an interim order was passed. Now, your lordship will kindly take the eye.
The interim order was there any interim order, that or interim order that your
Yes,
bids would
yes.
be also taken into account?
Yes. Now, please come to page, IA, my lord, 3462. Please come to page 16. After considering our prayer, this interim order was passed. My lord, at page 16 of the IA, 3462, last but one para. Considering that the petitioner has already submitted, as a lordship.
Yes.
Considering that the petitioner has already submitted the bids, which is scheduled to be opened on 2/9/25, and also considering the challenge to the terms of disqualification would require a detailed deliberation, which should be taken up on the next date of next returnable date. In the interim, it is provided that respondent shall consider the bids of the petitioner subject to further order of this court. So there was a clear direction of this honorable court that since final deliberation will take some time, therefore our bids should be considered. Then, my lord, thereafter the matter was listed on 8/9/25. The order is at page, operative portion is at page 19. By placing the communication issued by chief engineer, etc., dated 8/9/25, Mr. K. Gogoi Learned CGSC submits that scrutiny of the bids, including petitioner's bid, would take considerable time. Therefore, he may be granted time to file detailed affidavit in opposition. So what was given to understand was, my lord, that my bid is being considered.
Considered, yes.
Now, if your lordship should kindly come to the next page, page 20.
Hmm.
This is an internal communication of the my lord, the chief engineer to the learned council, my lord.
Mm.
Last para.
Decision is yet to be decided.
Moreover, technical bid has been opened on 2/9/25,
Mm.
and 6 agencies have submitted their bids, including the petitioner. These bids are yet to be scrutinized. Decision regarding qualification or rejection of the bidder is yet to be decided, and it will take almost 1.5 months to scrutinize the bids.
Hmm.
Then, my lord, next page,
Rejected.
my bid is rejected on 2 counts. Non-responsive as per 2222
Hmm.
and 222.432, which I have read. And the 2222 is at my lord page 98 of the petition.
Yes. Financial capacity.
Yes, bidder shall have a minimum net worth of the amount equal to 5% of the estimated cost of the project.
Hmm.
My lord, estimated cost of the project is about 75 crore, and my net worth is, my lord, 1125 crore. If your lordship would kindly.
More than that.
Much more, my lord, 10 times. Please come to page 22 of the I. Page 22. And listen, my lord, 1124.58 is my net worth.
Hmm.
Then my lord will kindly come to the next page. It's a chartered accountant certificate. 1124.5.
8.
So, my lord, regarding the ground of disqualification criteria, the Honorable Court says, notwithstanding that, you consider my case. Now, my lord, how can they say will not consider when court directs? It's a different matter that the considerations may not be given effect to until unless the Honorable Court finally decides the matter. Secondly, my lord, on the ground of net worth, they can't do. The requirement is 75.43 crores. I have got 1125 crores. So therefore, we have filed this IA, my lord. And most importantly, if a lordship should kindly come to page 24 of the IA. This is the financial bid opening statement, my lord. Now kindly see Larsen and Toubro and Abscon. One has quoted 1331 crore and Abscon has quoted 1701 crore. I'm not indicating my figure, but my bid is my lord substantially low. Much lower than this. And if they have rejected my case on the ground of that 2.2.2.4, then please come to my lord page number 9 of the IA. They also have similar collapse experience history of collapse of superstructure. Para 11, page 9, my lord. That pertinently both L&T and Abscon have had a history of collapse of superstructure, substructure of span of a bridge, flyover, viaduct, metro during construction in large scale. This is an out and out arbitrary exercise of power. When court says consider, how can they say will not consider or consider and reject? That consideration should be placed in a seal cover before this honorable court. Your lordship will decide the matter. Now, I don't think your lordship should permit them to go ahead with the, finalization of the tender before finalization of this great petition. If the plea is that there is urgency, that it is a national project of national importance, my lord, there is a judgment of the Supreme Court when there is. Copy हमको दिया था। Give me from that. I got it. I got two. My lord will kindly have this, my lord.
Just a minute.
Yes.
Please come to para 29. Page 24. The submission made by the learned counsel for the respondent that the project in question being infrastructure project and also one of mega project, this court may not interfere, more particularly in view of the fact that the agreement has already been entered into between the respondent BCCL and special purpose vehicle of respondent number 8 cannot be accepted. When we have found that impugned decision of respondent BCCL was grossly arbitrary, illegal, discriminatory, and violative of Article 14 of the Constitution. So, my lord, my humble submission is they will not issue the LOA without. Lordship will hear the matter next week. That's my plan.
Anything, Mr. Gogoi? You are representing the railways? Yes.
Yeah, my lord have to decide two things also.
Hmm.
Two motivation losses to decide here before deciding the intent protection which was paid by the petitioner in the miscase loss. The latest instruction I have lawsuit, the ground for rejection lawsuit. That exactly which was reflected in the lawsuit that pays. 21 of the miscase lawsuit.
Page?
Page 21 of the miscase.
21 of the miscase.
The reasons for non-responsive is lawsuit as per clause 2.2.2.2 and clause 2.2.243 Roman 3, Roman 2 and 2 of RFP lawsuit. For a moment, my lord may kindly come to first clause lawsuit 2.2.2.2 lawsuit.
Then you have 2.2.2.4.
Page 90 of the repetition lawsuit.
4 P 4 2 root 2. Here is a clause 97.
8 of the
90. 2.2.2. Okay. Bidder shall have minimum.
I can read it, lawsuit.
Yes, please.
The bidder shall have a minimum net worth within bracket the financial capacity of amount equal to 5% of the estimated project cost at the close of the preceding financial year. My lord may kindly mark it.
Financial year.
Preceding financial year.
Yes.
This lawsuit 2024 and 2025.
This was floated when 19/5/2025. So it has to be of 2024, 2025. Okay.
That was not given by the petitioner. Not submitted by the petitioner. This is one of the mandatory requirement lawsuit. We cannot relax it lawsuit. By relaxing that mandatory requirement, we cannot allow anyone to go for.
And this at page 22, it gives the net worth for the year 23-24.
Net worth even here's the lawsuit, Koros and Koros lawsuit.
No,
Not the lawsuit.
no, you have to listen to us.
Lawsuit.
The net worth shown is for the year 23-24, and your argument is that the net worth that should have been shown should have been for the year 24-25.
Preceding financial year.
So that according to you is 24-25. Okay.
Not only according to me lawsuit. Not only me lawsuit. Preceding financial will be 24 and 25.
25. Okay.
25. Another disputed fact that was not submitted by the petitioner lawsuit. That's why this is rejected on that one.
2.2.2.2. Yes.
2.2.
Then the next one.
Next one is lawsuit, the collapse history lawsuit.
There you say that he has not given the undertaking. Admittedly, one of the bridge has already collapsed. How can he give the undertaking? That is why he for this.
It's not an arbitrary clause. That clause is not only for him. All the bidders lawsuit.
Understood.
All the bidders.
But absence of the undertaking, he's not submitting an undertaking.
Then his bid will be not
responsible. He has moved this court to declare that, to remove that clause. This court has said that the court has said that you consider his bid notwithstanding that.
We have considered it, Lordship. What is the meaning of the consider, Lordship? We have considered it, Lordship.
Thereafter,
We have considered it and we have rejected.
when did the rejection come? This rejection is of which date? Yes. Counsel for the petitioner.
Yes,
When was it rejected? When did you come to know of the rejection?
28 October.
28th of October.
Yes, but can I answer to my learned
But
friends?
let him finish, otherwise, when were the financial bids opened? Because Larsen and Toubro, they are showing that this is the comparison and all.
27/8/25.
No, it will be
So that is the
after
closing date.
the rejection that financial would have been,
28/8/20.
same day.
Yes. Towards the bottom of page 24, below.
Okay, 28/2025 financial, okay.
At I think 5/30, 5/27.
Okay, let him finish, we'll again take
Yes.
up your, yes,
So, Lordship, may kindly come to page 16 of the miscase, Lordship.
page 16,
Page 16 of the miscase, Lordship.
yes.
Considering that the
Hmm.
first two paragraphs, Lordship, considering that the petitioner has already submitted the bid, which is scheduled to be open on so and so, and also considering that the challenge in terms of disqualification require detailed deliberation, which should be taken up for next returnable date. In the interim, it is provided the respondents shall consider the bids of the petitioner subject to further of the courts.
Hmm.
We have considered it. So, Lordship, what is the meaning of the consider? So, my lord, make.
No, we were also under the impression that once it is said to be rejected, the consideration has been made. It can be accepted or rejected only after it has been considered. That
Considered.
much, that
it
much
will-
we had in
It
mind.
will
But-
almost take 1 month, one and a half month times. 6 bidders is there, Lordship. All evaluation, more than 1.5 months.
So there is some evaluation still left.
No, Lordship.
All have been evaluated.
Everything is done, Lordship. It is in the final stage, Lordship.
Now, when the court says that the whatever decision you take on the after the consideration
Lordship, we have
will be
considered-
subject to outcome.
Yes, Lordship.
Now, if this, if you are allowed to proceed to give the work order to someone,
That will be subject to outcome of the petition, Lordship.
once someone starts the work, he puts
Then
in
Lordship,
every
here-
effort.
Then Lordship may hear today finally, Lordship. If he is entitled, Lordship allow him. If he is not entitled, Lordship may reject it. Otherwise, it's not a small project. It's a project of national
Understood.
importance, Lordship. We
Understood?
have 2 counts, we have rejected him, Lordship. We have rejected him on 2 counts.
Two
Lordship.
counts. The first count we are yet to hear him after you have responded.
Lordship.
You have given us some instruction, we will hear him on
Lordship.
that.
Lordship.
But otherwise, it is not about staying the entire process or whatever. What we are trying to understand is the rejection, or his rejection or acceptance would be subject to outcome of the writ petition.
Lordship.
Now he stands rejected.
Lordship.
That is subject to outcome of the writ petition.
Lordship.
If the respondents are to hold a situation as it stands today for another week, would that be more difficult? Or if you are allowed to go ahead creating a third party right, and then we have to overturn the entire situation,
Lordship,
which will be more
Then
conducive?
Lordship may hear it. Today finally hear it, Lordship. Today finally Lordship may hear it and decide it, Lordship. If there is any arbitrariness, any violation, Lordship may set aside the whole process, Lordship. If any arbitrariness, Lordship, if we can condone the Lordship 2.2.2.2, Lordship, and that particular clause, Lordship, then Lordship may, if any arbitrariness is there, Lordship may straight away set aside the whole process, Lordship. Lordship may hear it. Otherwise, this is a
But
project
in
of
the
national
absence
importance.
of your affidavit in opposition,
Lordship,
your stand that
on the basis of that, Lordship, our stand will be same, Lordship. If we file the affidavit, then also that 2 count will become. Yeah, I have the instruction, Lordship. Lordship, finally hear it.
That will be a doctrine, then the non-travelers would come in against you, Mr.
Lordship,
Gogoi. You have not
I
replied.
have placed the.
Because those are not the only
That
sentences.
Lordship, here regarding the interim order, why interim order can be granted or not, Lordship.
That
on
is
the
what we
basis
are,
of that-
that is exactly what we are trying
On the
to do.
basis of that, Lordship may decide it, Lordship. Whether Lordship says he deemed fit for granting the interim order, Lordship.
And that is what I'm
Lordship,
trying
here
to find out. That is what I'm trying to
Lordship,
do.
hear it finally in respect of interim order, Lordship.
That is what I'm trying to do.
So, for Lordship, for the moment, my Lord may kindly pass the judgment, what is the meaning of the consider? Then I will come up,
Yes.
then I will come everything, Lordship.
Okay,
Lordship.
this judgment, 2006 judgment,
Lordship, Lordship,
2006, 3 SCC 674. Yes,
Lordship. Paragraph 17, Lordship.
paragraph 17. Yes. Where the High Court finds.
Where
it.
the High Court finds the decision-making process erroneous and records its findings as to manner in which the decision should be made, and then directs the authority to consider the matter, the authority will have to consider and decide the matter in the light of the findings of the observation of the court. Then Lordship. But where the High Court, without recording any findings or without expressing any view, merely directs the authority to consider the matter, the authority will have to consider the matter in accordance with law, Lordship.
Yes,
We have
that you have considered the case. On the liberty granted by the court. Or the directions. Yes, yes, you have considered it.
We have considered it, Lordship.
Yes,
There is
there is no
no violation of the High
qualm on
Court's
that.
order,
There is no qualm on that.
Then Lordship, I will not go to the other paragraph. Specifically,
You have considered it and you have
specifically,
rejected the
Honorable
bill.
Supreme Court says that after findings are taken by the court and court has directed to consider it, then that consideration will be on the basis of the findings of the court.
I did not get you again.
If court have directed the respondent authority or anyone else, Lordship, to consider a particular case after a definite finding, Lordship, definite findings from the court, Lordship, then that particular authority or respondent authority
Has to abide by that
abide by the findings.
finding. If no finding is
If no
given,
findings,
it is up
as
to you.
per the law, Lordship, not me, Lordship.
No,
As per the
when I say
procedure
you,
is
I mean the respondent.
not as per the procedure prescribed in the law. Here procedure is the tender document, Lordship. Nothing else. We go by the tender document.
Yes,
We go by the tender conditions.
yes.
We have never violated any single stipulated condition of the tender, Lordship.
Now, when this court has to consider a prayer for grant of an interim relief, an interim stay, status quo, whatever. Usually we follow three processes. Three things we consider. One is the prima facie case in his favor. Second is an injury which is not replaceable by monetary compensation. A third and what perhaps would be necessary in this case is the balance of convenience. Now, his acceptance or rejection will be subject to the outcome of the writ petition. Creating a third party right at this moment, if it does not complicate, if you can argue that it does not complicate this situation.
Nothing will complicate, Lordship. Private interest cannot override the public interest. Number one. Number one, Lordship. It's a project of the public interest, Lordship. Whether there is any arbitrariness, any arbitrary.
That is what is to be tested. That is what is to be tested.
Any arbitrariness there, Lordship?
That remains to be tested.
So, Lordship, on the basis of that, I just before judgment. Regarding that party, Lordship, once finally hearing. Hearing intent to Lordship. Otherwise,
Yes.
my Lord may fix it also tomorrow also, I can place a bid. Correct.
Yes.
2007 14 SCC 517, Lordship. Paragraph 22, Lordship.
Paragraph 22.
22, Lordship. Judicial review of administrative action is intended to prevent arbitrariness, irrational, unreasonableness, bias, and malafide. Its purpose is to check whether choice or decision is made lawfully and not to check whether the choice or decision is sound. when the power of judicial review is invoked in matter relating to tender or award of contract, certain special features should have been borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance. My lord, may kindly mark it. If the decision relating to award of contract is bona fide and in the public interest, courts will not, in exercise of power of judicial review. My lord, may kindly mark that line also.
Will not.
If the decision relating to award of the contract is bona fide or in the public interest, court will not, in exercise of power of judicial review, interfere even if a procedural aberration or error in assessment or prejudice of the tenderer is made out. My lord, may kindly mark it. I again reiterated, Lordship. If the decision relating to award of contract is bona fide or in the public interest, court will not, in exercise of power of judicial review, interfere even if a procedural aberration or error in assessment or prejudice to a tender is made out. Lordship. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest. My lord, may kindly mark it. Or to decide contractual dispute. The tenderer or contractor with a grievance can always seek damage in civil court. My lord, may kindly mark. Attempt by unsuccessfully tenderers with imaginary grievances, wounded pride and business rivalry to make mountains out of the molehills of some technical and procedural violation of some prejudice of self or persuades courts to interfere by exercising power of judicial review should be resisted. Such interference, either interim or final, may hold up public. My lord, may kindly mark it. Such interference, either interim or final, may hold up public work for years or delay relief or spare thousands of millions and may increase the project cost mindful. Therefore, a court, before interfering the tender or contextual matter, in exercise the power of judicial review, should pose to itself the following questions. Whether the process adopted or decision made by the authority is mala fide or intended in favor of someone, or whether the process adopted or decision made is so arbitrary and irrational that the court can say the decision in such that no reasonable authority acting reasonable or in accordance with the relevant law would have reached, then lordship, whether public interest is affected, lordship. If the answer are negative, there should be no interference under the Article 226. Cases in other parts I left out.
Okay.
So, lordship, law is very specific.
Okay.
That was reiterated time and again. I will place it. Lordship permit, I can place the other part also. Thousand 16 SCC 759 lordship.
Yes.
I'm relying paragraph 30, 31, 32, 47, 50, 51, and 52 lordship.
32,
32, 47, 50, 51, and 52 lordship.
51 and 52.
It will cover lordship the regarding public interest part lordship.
30, 31.
Paragraph 30 lordship. But merely because the acquisition made are against the state or its instrumentalities does not mean that an aggrieved person can bypass established civil adjudicatory process and directly seek writ relief. Regarding lawsuits, and indicated that third party right and damage created. Then they have the appropriate remedy before the civil court also. In determining whether to exercise their discretion, the writ court would not only confine themselves to the identity of the opposite party, but also the nature of the dispute and relief paid for. Thus, although every wrong has a remedy, depending upon the nature of the wrong, that would be defined forum or readiness.
Yes.
Then also 31. In cases where a contextual right is infringed, writ should ordinarily be the appropriate remedy. In tender matters, such can be either when a party seeks to hold the state or to its duty of treating all persons equally or prohibit it from acting arbitrarily, or when the executive actions or legislative instruments are challenges for being an contravention to the freedom of carrying on trade and commerce. However, writs are impermissible when the allegation is solely with regard to the violation of contextual right or duty. Hence, the person seeking writ itself must have also actively satisfied the court that the right it is seeking is one of the public law and not merely contextual. In doing so, a balance is maintained between the need of commercial freedom.
Yes, we have gone till 52.
Lawsuit.
We will repeat, yes. Okay.
Lawsuit.
So,
Before that lawsuit, I'm relying specific relief act lawsuit. Because we have one different.
Senate. Is your,
If not lawsuit, may take this law.
no, you just read it out kindly. What was, yes, we have it. This is
Page 24, section 41 lawsuit. Injunction when refused lawsuit.
41. Page 20?
It will same book then page.
No.
Lawsuit may kindly page section 41 lawsuit.
41, yes, injunction when refused.
Injunction when refused. An injunction cannot be granted. Lawsuit H small l lawsuit. Insertion lawsuit. If it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provisions of the relevant facility related thereto or service being to the subject matter of such project. It's an infrastructure project of national importance. It's a second route, rail line and route come beach lawsuit in the near the existing Horaigat beach lawsuit.
Okay.
That particular
Yes.
2022 6 SCC 1 to 7 lawsuit. Paragraph 19, 20, 21, 22, 23, and 26 lawsuit.
22, 20?
19, 20, 21, 22, 23, and 26. Paragraph 19, in respect of the lawsuit, the provisions of specific relief act lawsuit. And 20 is the expert committee's report in respect of the insertion of that particular clause lawsuit. And 21 and 22 lawsuit. In 21 lawsuit.
Yes.
Since the construction of road is an infrastructure project and keeping in view of the intent of the legislature, and infrastructure project should not be stayed, the High Court would have been well advised to hold its hand to stay the construction of the infrastructure project. Such provisions should be kept in view even by the writ court while exercising its jurisdiction under Article 220 of the Constitution of India lawsuit. Then lawsuit 23.
20. 23 we have read.
In view of the above judgment of this court, the writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer. The court does not have the expertise to examine the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. Court should be even more reluctant interfering with the context involving technical issues, as there is requirement of the necessary expertise to adjudicate upon such issues. The approach of the court should be not to find fault by magnifying
So,
glass in its hand, rather the
Mr. Gogoi, the thrust of your submission is that project should not be kept on hold. Whatever be the outcome, will be the outcome when the writ petition is decided. As of today, this court should not bar the respondent authorities from going on ahead with the project. That is how we have,
Yes, sir.
because 26 is also of the, say, on the same line.
regarding tender condition, just I lordship, let's do that, tender conditions. Do that, man.
Yes.
Only paragraph I indicate.
Mhm.
Paragraph I indicate.
Hmm.
2023 SCC online SC 1223 lordship.
And the paragraph?
35 and 36. 35 is the lordship findings of the Tata Motors lordship. That was also I have handover lordship. Very good.
Yes. Okay. Small paragraphs come.
Paragraph 35 lordship is reiterated the
What is given here?
what is given here in paragraph 50. Here is paragraph 50 lordship. Paragraph 50. Then paragraph 36 lordship.
Sin.
Paragraph 36,
Read.
the court ought to defer to the discretion of tender
Yes.
inviting authority, which by reasons of having authored the tender document is best placed to interpret their terms. The
This
court ought-
is the same as the earlier one or two judgments where the court says that your authority is best.
Another one is Balaji Vensa, paragraph 9 was, I am relying.
We appreciated his way of having that spiral bindings, which made it easy for us to. No, it is okay. Okay.
Just
Yes.
morning I came to know that particular case is there.
Okay.
Is here was.
This one which?
This one paragraph 9 was.
Paragraph 9.
Paragraph 9 was.
Okay.
Now, so far as the impending judgment and order passed by the High Court dismissing the writ petition is concerned, what was challenged before the High Court was one of the tender conditional clause. The High Court has specifically observed that noted that the justification of the providing clause so and so, the said clause was to be applied to all the tenderers and bidders. Here also all the clauses applied to all the tenderers and bidders lordship. It cannot be said that such a clause was a tailor-made to suit a particular bidder. It was applicable to all. Owner should always have the freedom to provide the eligibility criteria and the terms and conditions of the bid, unless it is found to be arbitrary, malafide and tailor-made. The bidder tenderer cannot be permitted to challenge the bid condition clause which might not suit him or not convenient to him. lordship. As per the settled proposition of law, as such it is an offer to a prospective bidder tenderer to compete and submit the tender considering the terms and conditions mentioned in the tender document.
Done.
Here also lordship, everything is applicable for all laws. Regarding why lordship, we have put that particular conditions lordship. Regarding financial conditions also there lordship, at Michigan number I am relying.
No, since the financial conditions imposed in the writ petition in the NIT is not under challenge in the NIT, we need not evaluate whether it is correct or not.
Only that count we have, two counts we have corrected.
It is not under challenge.
This was also one of the ground. If one ground, the particular tender is rejected, lordship, it cannot be revived in another ground also.
Did we have this before? Which para?
Paragraph 23 lordship.
23.
23 lordship.
Okay.
Lordship.
Fixation of a value of a tender.
Paragraph 23.
Certain preconditions have to be laid to 23 I'm reading. 23B I was.
C and D, Lordship.
C and D.
C and D, my lord,
Okay.
kindly.
We'll keep this in mind. Yes. 23 C D. Yes.
Regarding Lordship, that there are other successful bidders is also there. They are not made party here, Lordship. Regarding that particular point also, their abscon has already law is settled in paragraph 18, Lordship.
So bidders have become successful during pendency of the writ petition. How could they have imagined whom to make a party?
Lordship.
That will not that will not impress the court. Yes.
I left out it. Otherwise also, Lordship, regarding that Intempia, one of the mega project, Lordship, this was approached before this court and honorable court observation is here also.
So let us.
Of the tender condition document is there, Lordship. Regarding in that particular case, Lordship, document was submitted, signature was not put, Lordship. That's
It
why,
did not inspire the confidence of the court
Lordship,
that it is an authenticated document and
No,
therefore the interim was rejected.
they have submitted the document, Lordship, but
The signature was not there.
the detailed signature is not there.
So therefore the court says that the materials on record does not inspire the confidence of the court.
So, Lordship, paragraph 12 also, Lordship.
I mean-
Paragraph 12, settled provision of law, Lordship.
Uh,
Paragraph 11, Lordship. Paragraph 11. The settled proposition of law,
Hmm.
the settled law stipulates that the best judge to decide whether a requirement of submission of the documents in the manner stipulated in the bid document is mandatory or not, Lordship. Here also 2.2.2.2, Lordship, preceding financials here,
Whoa.
they have not submitted, Lordship. In this particular case, Lordship. So, Lordship, mandatory or not should be left to the wisdom of the authors of the tender documents, and the judicial interference is limited unless perversity
Now,
of qualified years can be demonstrated.
Notice was issued making it returnable on 21/8.
Just by regarding interim pair.
What happened on that day?
Lordship,
On 21/8/2025, it was made returnable.
first term, that pair is never considered, Lordship. It is pending. Now they are filing an impeding petition or the successful bidders.
Now, you had taken time. By you, I mean the respondents had taken time twice or thrice to file the affidavit in opposition. Nothing has been
Fixed on 12/11. Otherwise also, main matter.
main matter.
Paragraph
12,
12. Today,
11.
Lordship, hearing in respect of interim pair.
Huh.
Today, hearing in respect of interim pair,
Hmm.
not the final.
Hmm.
If Lordship wants to finally dispose of, I can ready, Lordship, without filing affidavit. On the basis of that instruction, I can submit, Lordship.
Okay.
That authority they have given to me, Lordship.
Okay, once it is fixed for 12/11, let us have it on 12/11. We will not dispose of the whole matter today. We'll consider the interim part only.
The interim part is considered. only.
Aha.
Paragraph 12, Lordship.
Yes, we have seen that.
This court further finds it pertinent to observe that the project in question is a project of national importance. There was a construction of road, Lordship. Here the construction of the bridge, second bridge of Brahmaputra. It is very much necessary because the earlier old one is, Lordship. These are, Lordship, very stressed, Lordship, regarding that part. That bridge, Lordship, has already gone.
Yes.
So I got peace, Lordship.
Yes.
This court further finds it pertinent to observe that the project in question is a project of national importance.
Read.
But period for complete, here is period for completion in 3 years.
Hmm.
Completion of project is so and so days. Since a very strong case made out to state the tendering process, it would not be the interest of justice and also the settled law to stall the tender
Tender
process.
process.
Or the delay in a finalization of the tender would result in the escalation of cost, which in effect would cause impact to the public exchequer.
Hmm. Okay.
That is. Which is my humble submission in respect of the interim pair lordship.
ठीक है.
And so lordship, on the basis of the law laid down by the Honorable Apex Court and the prescription prescribed by the Specific Relief Act lordship 41(8)(c) lordship. The law laid down in respect of the public interest by the Honorable Apex Court. That at this stage, lordship, on the basis of the law, lordship, the interim order cannot be considered. This is my humble submission. The project is a most important project, is a national importance. There is no arbitrariness. The clause which was inserted in the tender documents is applicable to all lordship, not the petitioners alone lordship. Is applicable to all lordship. And we have rejected him 2 counts. He has not submitted the financial capability of preceding years. Preceding years is 2024-25, preceding financial year. He have submitted in 2022-24 lordship. 1 count, another he has not submitted the history of the collapse. In the Patna High Court judgment, just by lordship, pointed 1 paragraph. They have not shown lordship that particular paragraph.
That is a page.
Page 200 lordship. Patna High Court judgment starts from 198. Page 200. What was the undertaking and rule of the petitioner at the relevant point of time? Paragraph 2 lordship. They have not read the paragraph 2. They will start from paragraph 3. So lordship, I will start from paragraph 2 lordship. Page 200 lordship. Now the agency who the managing director has undertaken to construct the collapse funds lordship by itself without any additional cost to the government. The undertaking by the managing director is produced through an affidavit dated so and so. That part is the undertaking part lordship. That's why on the basis of the undertaking given by the managing director on behalf of the company, that PIL was closed lordship. The Honorable Patna High Court never give them clean sheet lordship. This is their own admission and own volition lordship. They have given the undertaking. On the basis of undertaking, the PIL was closed lordship. It is not the case that Honorable Patna High Court has given them clean sheet lordship. It is admitted fact that they themselves admitted they have made it from their own pocket, own cost, not from the government. What does mean lordship? It is admitted fact that only 2 counts we have rejected. Patna High Court judgment nowhere lordship. It is neither where, neither there lordship. They have not given me clean sheet lordship. It's a national important project. It's a not only national, it is a national important, especially for the people of Northeast lordship. This is my humble submission lordship.
Okay.
Wait,
Yes, sir.
Lordship.
Yes, sir.
Yes. But after hearing my learned friend, I have a feeling that 226, I think High Court should amend the rules and say contractual matters don't come here, go to suit. And Article 14 also, I think some provisos should be added. My Lord, a decision is an authority for what it actually decides. Every sentence in a judgment is not to be read as a statute. Now, in this case, my Lord, there is already an interim order of this Honorable Court. Therefore, notwithstanding whatever my learned friend has argued, that consider my case. Since you wanted to reject my case, was it not incumbent upon you to seek leave from the court? Was it not incumbent upon their part to seek leave of this Honorable Court that you have given us liberty to examine his bid? We have examined this bid, but on account of XYZ reason, we cannot consider his case. Therefore, please give us liberty. Leave. On the contrary, my Lord, a letter was written to my learned friend by the chief engineer, whereby it was informed that 6 bidders, including the petitioner, submitted their bid. Their bid is being considered. Now, what was the implication of my learned friend is saying that don't pass an interim order? That stage is over. Interim order is passed.
You have, that interim order has attained finality. You have not filed any appeal, you have not filed any vacation stay order. Therefore, the entire argument is fallacious, is highly preposterous. Well, there is already an interim order. There is no prayer for vacation of the interim order. And the argument is don't pass an interim order. Mere reading of judgment is not enough. You must understand the implication. The implication of the interim order was that you consider his case subject to further orders. In other words, for the timing you consider his case, keep it in a seal cover, whatever. That means I have to be evaluated. Maybe they will not give the work to me, that's a different thing. But whatever is the decision, they will put it in a seal cover and they will place it before the court. On 12/11, court will take a call. If court finds that this insertion of this clause was wrong, then I win. If the court finds that no insertion of this clause is not wrong, then my rejection is okay. But can you choose this middle path? So this it is not acceptable below. Any amount of argument will not help the other side. Now, regarding the other ground of my rejection, my lord, that 2.2.2.2, my lord, one needs to have some knowledge of accountancy also. My lord, when the financial year ends, 31/3/20, then what is the time till when one can submit, my lord, balance sheet? It is 30th of September 2025. On that day, my lord, I couldn't have produced the financial soundness certificate for the year 24-25 because that will start only after 30th of September. In fact, my lord, my credit worth is now 1331 because I submitted that document on 27/8/25.
27/8/2025,
2025.
you participated in the bid.
No, I get that certificate is of the CA is dated. Sorry, my lord, 22/7. I'm sorry, 22/8/25.
On 22/8/2025, you had the certificate on 28/2/2025.
For
You
the
submit
financial year 23-24.
24, and the next certificate, according to you,
Will be ready
you would have
post 30th September.
post 30. Okay.
My lord, therefore, I think lordship should direct them to produce the financial soundness certificate of the two successful bidders. They also possibly they cannot give.
Okay.
Because accounting year is uniform for everybody. My lord, we also pay. My lord, yesterday, my lord, my accounts is audited. I filed my return yesterday because my date is up to 31st today. And for the general public, it is 30th September. So before that, nobody files. I have for the current year, but I can give it post 39/2025. In which case, it is 1,331 crore. So, my lord, if this is not arbitrary, in which judgment Honorable Supreme Court has said that if there is violation of Article 14 in contractual matter, a court should not interfere. My lord, Specific Relief Act is a statute. Article 226 is constitution, my lord. Lordship would recollect. When, my lord, Administrative Tribunal Act was framed, a provision was made against the order of Central Administrative Tribunal, appeal lies to the Supreme Court. In Sampat Kumar's case, in 1993, Supreme Court upheld that provision. Eventually, my lord, in L. Chandra Kumar, when the matter was referred to Constitution bench, Supreme Court say that 226 is inviolable basic structure of the Constitution. Its width, its contour cannot be controlled by parliamentary legislation.
Even for the
Specific Relief Act, Section 41H cannot control your power under 226. Let us be very clear about it.
even
If any
for the
proposition is
AFT,
required, my lord,
it
then
comes
let
down.
us go to the 13 judges Constitution bench. So therefore, my lord, it's a very simple case. There is an interim order operating, saying you consider my case. That means you consider my case on merit. Thereafter, on the ground of XYZ, they do non-compliance, that cannot be done. Because you never sought for modification of that order. Neither you sought leave. So therefore, it's a simple case. They will consider my case. not on account of any non-conformity, otherwise on merit. If on merit they find that no, somebody's bid is better, somebody is better placed, that's a different aspect. But as I have already submitted, my lord, the L1 bid is 1331 crore and my bid is substantially lower. So government stands to gain. Public interest is also, the public interest, that is also a component of public interest. And my learned friend says that how come these petitioners can approach this honorable court? Because it is a public law remedy. What is a public law remedy? Whenever there is any violation of the fundamental right. Here is a case where there is violation of fundamental, because I have been denied equality of protection, equal protection of law, because I stand on a much better footing. Now I am sought to be, my lord, obliterated. And why initially that was 5 years was brought down to 3 years? This disqualification clause, initially it was 5 years. To suit somebody, my lord, they have brought it down to 3 years. All these aspects I will address at the time of final hearing. Now my simple prayer is, my lord, 12/11 is the date fixed. Plus you will hear the matter on 12/11. Till that, my lord, they will not issue this. They let them proceed with everything. In any case, they will take some time. Today we are on 31st. Hardly 10 days is left. 10 days, my lord, the heaven is not going to fall. No matter how much of, urgency my learned friend may express. Till then, my lord, they will not issue the final work order. And we'll come up with everything and let them file their affidavit, or else they will take the risk, because each and every statement will be accepted by them. It's their call. Time was taken by 10. Court wanted to hear it on 21 of 7 days thereafter. They could not file the affidavit. That is the urgency. So we are not coming in the way of this honorable court in, disposal of the case. Our simple case is there is already an interim order. Now that interim order attained finality. Now that interim order is to be given a meaning. So this is not the occasion to determine when an interim order is to be passed. Interim order is already there. So there is no question of making any prayer that no interim order can be passed.
The only thing we are trying to now assess is whether this creation of a third party right at this stage.
No, my lord, there's nothing. The other judgment I had placed, there the agreement was entered in. The
Yes,
judgment which I had placed.
And that is causing us to rethink.
Yes,
1 second.
Yes.
That is causing us to rethink the issue.
No, LOA has not been issued, my lord. No third party right.
No, LOA has been issued. No, perhaps I have not been clear. Allowing them to proceed may create a third party right, is what I was thinking.
No, I was trying to concede to that extent, my lord. Or if your lordship wants to prepone the date of hearing, I don't know. Only thing is, my lord, 6th time tied up, I can have the hearing on 7th.
No, if it is fixed for 12, we would not change the
Yes,
date
it
because
is
of
already
this.
fixed.
We are not in mood to change the
And
dates.
their instance, my lord, this date was given because they have to file their affidavit. Because court was inclined to hear the matter on 28th. And we are also ready. So we are not coming in the way of, my lord, disposal.
Just to indicate regarding that time period court has taken. So as because the procedure was going.
The evaluation was going on.
That is the reason, Lordship.
And once the evaluation is
Otherwise,
complete, you can
one
have a
thing is-
comprehensive.
One thing is, can Lordship under Article 226, Honorable Court directed the authority to do a particular things which is not in the NIT conditions?
That we will decide when we decide the repetition, not today. That we will not decide today. Not Mr. K. Chaudhary, Learned Senior Counsel, assisted by Aditya Mehta, appearing for the applicants. Also heard Mr. K. Gogoi, Learned Counsel, appearing for the Learned CGC, appearing for the Union of India, for the respondent, opposite party number 1 and 2. For the railways, it's the opposite party number 1 and 2. You'll have the order by 1:15. I'll dictate it inside the chamber. You'll have it by 1:15. Because we'll have to quote everything and all. I'm doing it here. Choose out the paragraphs and read. 1:15. I'll give us any case. To find it here, video. Put it here. এইখিনি লাগিব হা Thank you.